Josh Denbo, consumer protection attorney here. I'm going to talk today about how scammers use the produce the note defense as a means to trick people out of money. Look, I've talked about the UCC3 already. This is kind of like the next stage in UCC3 analysis. If you want to watch the UCC3 deep dive, it's all about 2 minutes and 30 seconds and it's elsewhere on the channel. Here's the thing. If you're looking for this video for this particular topic, you're probably in trouble on your mortgage and you're probably receiving a bunch of letters and emails and calls from folks promising all kinds of things. If any of them are promising you a solution by arguing that the bank doesn't have a right to enforce the note because they lost it, because that's called the produce the note defense, and it doesn't work. Then there's a reason it doesn't work. The Uniform Commercial Code, Article 3, says if you possess the note, you have a right to enforce it. You can look at my other video for that. But notes do get lost. So what happens if someone loses a note? Do you own your house for free? No. Uniform Commercial Code, Article 3, Section 308, UCC 3-308, you can go look it up and read it for yourself, basically says if the note is lost, the note can be recreated, so long as there is reason to believe that the original note existed and existed in the same terms and all those kinds of things. And traditionally, the courts have not had a problem recreating the notes. In fact, the people that drafted the UCC and continue to work on it are basically a bunch of law professors. And they came up with UCC 3308 that said, if you lost the note, then you have to go and you lost the note, then you can create an affidavit of lost note because you're the one who lost it and you know it was lost, you know what the terms are, blah, blah, blah. That makes sense to me. Problem is the industry couldn't handle that and they made a bunch of mistakes and a couple people got free houses, which really wasn't the goal of the law professors creating the UCC. The UCC was designed to create a system in which notes could be bought and sold and enforced and paid, and everybody could be tracked and done the right way. New Jersey didn't adopt that change, which moved off the requirement that the party that lost the note create the affidavit of lost note. And another state also didn't move off that change. So New Jersey and this other state maintained, if you're the party that lost the note, you have to be the one to create the affidavit of lost note, or else this new party doesn't really have the proof that the note was ever really in existence. Okay, a former associate of mine took this issue to the New Jersey Supreme Court and lost. And the New Jersey Supreme Court said, I know the legislature hasn't adjusted the rule to the modern UCC 3308, but this is designed to be a standard rule in all 50 states, and we're going to follow the rest of the 50 states in their analysis of how lost notes work. So too bad, you lose. You haven't demonstrated that there's indication of fraud, that this note didn't exist, all those kinds of things. So basically, if someone is telling you that they can win your foreclosure case by demanding a copy of the note, that's a lost note defense, and they're scamming you. Stay away.